Thanks very much for joining us. We sometimes have chairs for these things, but I'm self-introducing here. So now this seminar is actually aimed mainly at those who are relatively new to class actions. What we're really looking at doing is covering some of the developments in the class action space and talking about some of the key features of class actions. But before I start, I'd like to introduce Katie, who, after working in London with a New York firm for about a decade, Katie joined the New South Wales Bar in 2019. She's recently come to Greenway, and she's got a broad commercial practice with a particular focus on international arbitration and domestic commercial arbitration. For those who don't know me, my name's Hernan Pintos-Lopez. I'm a barrister, been at Greenway since 2017 and been at the bar since 2012. And I mainly practice in class actions and a smattering of other things like inquiries and government inquiries and coronials and those sorts of things. So I'd like to start by just giving a brief introduction to some of the key aspects of how class actions work, and then undertake a bit of an overview of different kinds of class actions, and finally end up with a discussion of some interesting new developments in the class action space. And in particular, I'll be looking at some new developments in relation to human rights, class actions, and natural disasters, and also Katie's going to focus on emerging class actions in relation to cybersecurity and privacy, and also environmental ESG type issues and climate change. And she'll also be speaking about some interesting cases to watch over the next 12 months. So that's broadly what we're going to cover. So I'm sure many of you already know this, but I think one of the things about, and I'm going to be focusing primarily on Part 4A of the Federal Court of Australia Act, but I think one of the things that most people who are new to the area have difficulty grappling with, I guess, is it's a very unusual feature of class actions, which is that they are they involve the determination of rights of people who are not before the court, and that really does mark them out as being quite different from other sorts of proceedings that you might see. And it operates by statute, but the best way of understanding them, at least from my perspective, is they're a mechanism for determining common issues. And when you see it in that light, it provides a framework, if you like, for determining common issues. Now, what that means, in effect, is that in a procedural sense, it's just a procedure. It's neutral as to the content of the proceedings that are brought. Now, obviously, some sorts of proceedings lend themselves more readily to class actions. But the thing about the framework is that it's flexible, it's neutral, and it allows proceedings to be brought on behalf of people who might not otherwise be able to bring proceedings. So that's fairly important. But if you look at the structure of Part 4A, what you'll see is that there are a number of features of it that really are about understanding it as a means of determining those common issues. And so Section 33C is sometimes described as the gateway provision, which you have to get through in order to be able to be a class action under Part 4A. One of the key features of part of 33C is that in addition to having 7 or more persons and having a commonality of circumstances, the claims of all of the persons who are in the group have to give rise to a substantial common issue of law or fact. And it's that it doesn't have to be an issue that, if it's determined, will fundamentally affect the proceedings, but it does have to be substantial. Now, what's relevant here to understand is that it's that commonality that you see is threaded through a number of the provisions in Part 4A. And I'll just touch upon a few of those before we get into the broader review. So I did just want to mention, I did just touch on it a moment ago. So it's been held that the common issues have to be serious and significant, but they need not be likely to have a major impact on the litigation. And what it means is that there may well be features of claims that not all group members necessarily have the same interests, and you may well have persons having claims where some aspects of their claims will not be resolved through the class action. And so it may be for some people that they have to take their own proceedings, or that the court must make orders for those proceedings to be dealt with separately. And I'll touch on that in a second. But so what we see here, as I said, must be serious and significant, need not be likely to have a major impact. The court determines the common issues at the initial trial. So normally what you have is you have a hearing that relates to a lead applicant. It might be more than one lead applicant. That initial trial will determine and make findings in relation to that lead applicant, but in addition to making those findings about that person's questions of liability, questions of damages, but also determining common questions. And so you see there what I was talking about before, that it's this unusual feature where group members are not parties. They're not before the court. They're not putting on evidence. But the way the proceedings are brought, they're effectively brought on behalf of those persons. Now, you also see, for example, Section 33H, the application itself has to specify the questions of law or fact that are common to all of the group members. 33N, for example, there's a great deal of flexibility in Part 4A. There's the ability for the court to determine that the proceeding should not continue as a class action if it's considered that it's in the interest of justice for that to occur. So one of the features that's there, one of the considerations is subsection 1C, where the representative proceeding will not provide an efficient and effective means of determining, of dealing with the claims of the group members.
Has that happened very often?
Lots of applications are made under 33, and it's increasingly becoming a new battleground, because 33C is, as I said before, it's not a very demanding standard. And so people often fight over whether or not there is in fact properly a group. But increasingly we're seeing that there are certainly plenty of people bringing applications for what's referred to as declassing orders. But I'm not sure how much it happens in practice. I'm not sure how successful they are. You see lots of 33N applications that don't succeed, maybe some that do, but that tend to see that. So, but what's important there is what 33N recognises is that there may be a point in proceedings where it becomes quite apparent to the court. And what's important here, and I haven't included all of the text obviously of the section, but the court may, on the application of the respondent, or of its own motion, make an order under 33N. So sometimes there comes a point in the proceedings where it becomes apparent that it's not appropriate, for example, that the proceedings continue as a class action. Now, just briefly touching on 33Q, which gives the court the ability to create subgroups, for example, to deal with issues that are specific to particular group members, but not all group members. Now, I have to say that more often than not, what I tend to see is that an applicant comes along and already has established subgroups, has worked out that there are different interests for different groups. There might be, for example, a claim. Some people have property damage. Some people may have indirect losses. You find that there's an awareness, certainly on the applicant side, that there's benefit to establishing those subgroups from the outset to make quite clear that there are different groups with different issues to be determined. Now, what you see in 33S is more evidence of what I'm talking about, which is a power that the court can direct that separate proceedings be commenced and conducted by particular members. So the court can, for example, say, in relation to a subgroup, that subgroup should bring separate proceedings and continue as separate proceedings outside of the current proceedings. Can also do the same thing in relation to individuals if those claims are best determined outside of the class action. So what it is very much a flexible process about determining what's the most optimal way of determining the common issues that affect the group members, and providing various off-ramps, as it were, for claims that are not, if you like, best advanced through the class action procedure. Finally, I just touch on there a couple of further things, which is 33Z, which lists all the powers that the court has. And in addition to the ability of determining issues of law and determining issues of fact, the court has powers to award compensation. The court also has the power to make such other orders the court thinks just. It can grant equitable relief. There's just a tremendous suite of powers there in Part 4A. And again, it adds to, if you like, I think the procedural appeal of Part 4A because of the powers that are there. And finally, important to understand 33ZB, because what it does is that, other than in relation to persons who opt out, the effect of judgment is that it binds all of the group members. And so that's what I was saying before about it affects the rights of people who are not before the court but are described in the proceedings. And that really is a very unusual mechanism. There's not many proceedings where you see that. It's statutory, and it's the, if you like, the engine that makes it work. So now some of you who've practiced in the area will have come across the term Merck orders. Certainly, ever since Merck, Sharp and Dome, it's been understood that there's an importance in formulating the common questions that will be determined by the court. This is the judgment where that determination was made, but I think what I'm flagging there, and what's important to understand, is that the whole purpose of the trial, the argument in Merck was whether or not the trial should be permitted to develop organically, as it were. The full federal court formed the view that it was, in fact, important to determine in advance what the issues to be determined would be, especially in circumstances where there was a disagreement between the parties about what those issues would be. So for those of us who practice in the area, Merck orders are very much a part of life. Outside the federal court, they're not always referred to as Merck orders, but they are really it's that formulation of the issues that will be determined, and those are precisely the things that will bind the group members basically at the end. So those are just a few, if you like, features of at a very basic level of the framework for class actions. But really what I was trying to really introduce is the idea that it's about this determination of the common issues that really is the key feature, if you like, of class actions. And so what I described before was the flexibility, the neutrality of the procedure. You tend to see, for example, a lot of consumer or product liability cases. You tend to see a lot of investor class actions, but there's nothing about the class action framework itself that drives that per se. The framework itself is neutral. So what I want to do now is just give a bit of an overview of different sorts of class actions that we see, and then focus in on a couple of areas where there are some new developments, and it's sort of interesting to look at those areas. So overwhelmingly, most class actions tend to fall into the consumer and product liability group, or the securities and financial products group. That's where most of the activity is. And I've just included here just some examples of some cases. And really what you can see there, particularly if we look, for example, at the consumer and product liability cases, they'll tend to be brought under the Australian consumer law. Sometimes there are allegations of negligence as well, but they're really quite varied. So you see, for example, Gill was a case about therapeutic device, pelvic mesh. Williams Toyota was a case about diesel particulate filters. Very different sorts of cases, very different sort of material, very different sort of evidence. But really, what you can see there is that quite often you will have claims about whether or not particular provisions of the Australian consumer law have been satisfied, and the class action provides a vehicle, if you like, for claims on behalf of potentially hundreds, if not thousands, of people who might be affected. Now, and I also mentioned there the Ruby Princess case, which is a case that I was involved in, and that case involved some claims that were being brought on behalf of some 3,500 passengers. So that's just an illustration of the sort of scale of those sorts of cases. Now, there's often great complexity in these cases, and in sort of creating this typology, I'm not trying to say that every case falls into this category, but you find quite often that there are common features that appear. And so, for example, in the investor space, you find that there tend to be class actions with some reasonably common features. So there will be an allegation that, or claims that continuous disclosure obligations have not been observed. There's been a breach, and quite often some sort of associated misleading and deceptive conduct, where the idea is, from the investor's perspective, had the respondent done what they were supposed to have done, they wouldn't have bought the shares, and they wouldn't have, for example, their financial position would have been better off on a counterfactual. So a recent example that we have there is Zonia Holdings, where in fact I think from memory the group in that case was, Zonia was in fact unsuccessful in that case. But really I'm not sort of looking to get into a great discussion about each and every one of the cases. It's really more just trying to explain a typology, if you like, of different sorts of class actions that we see. In recent years, we've also seen quite an expansion of employment cases, and Elliott Card is just an example of that. So in that case, they were basically seeking compensation orders, some declarations, and some pecuniary penalties under the Fair Work Act. Statutory cause of action, as it were, but using the class action framework. And some of you may have come across the Sydney Light Rail case, which was basically a nuisance claim. So you can see the great diversity of the sorts of cases that are possible within this sort of broad class action framework. Now, some of the cases we've just touched upon brought in New South Wales, where the framework is actually very similar to Part 4A. All right. So I think one of the interesting areas that's been emerging in recent years is in the human rights space. And for example, we've seen stolen wages cases, for example, in Northern Territory. We've seen and Street and State of Western Australia. It's a very, very substantial case, settled late last year for $180 million. That included, I think it was about $165 million for the group members. And there was also an apology in the Western Australian Parliament was part of the settlement. That settlement was approved in Street, in that case that I've cited there. But there have been other cases such as Wootton, which is a slightly older case. But most recently, there have been some proceedings commenced in the federal court in the Victorian Registry, funnily enough, cases against State of Queensland. And that's Gunning and Burns. Now, I just wanted to just talk a little bit about those, because what's interesting about those cases is that there are two related proceedings that are effectively advancing similar sorts of claims. But in the case of Burns, what you have is a woman who alleges that she was removed from her family's care by the state, placed with non-Indigenous carers, and that the effect of that was that she suffered a loss of cultural connection, and that was the things that occurred were wholly or partly because of her race, and that consequently the underlying claim is one for breach of the Racial Discrimination Act. Now, in the case of Gunning, again, you have a First Nations man who, in that particular case, alleged that his children were removed from him, again, contrary to prohibition in Section 9 of the Racial Discrimination Act, with the effect that his human rights have been impaired, again, contrary to the Racial Discrimination Act. But what's interesting here is that basically you have a class action vehicle being used where the claims that are being brought are in fact racial discrimination claims. That's the essence of those claims. And again, Street was a complex case and involved a number of different sorts of claims, but there was in fact a Racial Discrimination Act claim which was part of Street. Now, one of the interesting sort of developments in the last sort of couple of years there have been some amendments to the Australian Human Rights Commission Act that allow for representative applications to be made to the federal court. What's interesting about those representative applications is that they have some of the hallmarks of class actions, but they require first that a person must bring a complaint in the commission. So it's only if the complaint in the commission is terminated that you can then, and in certain circumstances, you can then seek to bring proceedings in the federal court. What's interesting about the representative procedure under the Australian Human Rights Commission Act is that it does allow persons who are not affected persons to bring claims. So you can have trade unions can bring claims and complaints to be accurate when talking about the Australian Human Rights Commission. A trade union can bring a representative complaint on behalf of affected persons, and you can also have potentially advocacy groups and others bringing complaints on behalf of affected persons. But there are certainly aspects of the procedure that I think are likely to favour people using Part 4A. Part 4A has a flexibility to it and a power that, as I say, comes from the provisions that are there and the flexibility that the court has to make orders, which I think will probably mean it continues to be of interest. And
would that particular one require something systemic has gone on that would link people, members of the class?
What it requires is the Australian Human Rights Commission Act creates, if you like, a procedural framework for the bringing of complaints to the Commission. But typically there has to be a form of discrimination which is either against the Racial Discrimination Act, the Sex Discrimination Act, and that's where the content of the claim is found. So, for example, in the case of racial discrimination, it's Section 9 of the Racial Discrimination Act that prohibits discrimination on grounds of race. So that's where that would. That's where the content is. I'm not sure if that answers your question exactly, but yeah.
For there to be a class, the class would have to be affected in that broadly same way.
Yes.
They've been racially discriminated against, and that might suggest that there's been a pattern or something.
Yes.
Systemic that's...
Yeah. Well, Section 9 requires an act. So there's got to be an act that is a I think it's a restriction. Just make sure I've got the right words. It requires an exclusion, restriction, a preference. You've got to have that kind of conduct. It has to be conduct based on race, and it has to be conduct that impairs a human right, a recognised right. Now that's a tremendous oversimplification of what's a very complex section, but those are the key features of it. Now, just briefly, I just wanted to flag what's going on in the sort of the natural disaster space, as it were, because although these cases are not new, there's an interesting thing that has been happening in the last few years, which is there have been some cases that are brought that resemble class actions, but they're not class actions. And I was in one last year with Richard Cheney, who's also here at Greenway, and Andrew Gurgis, who's here at Greenway, and that was Creary. So Creary was interesting because after several weeks of hearing, it settled, but basically it was 4 sets of proceedings that were brought together on behalf of some 398 named plaintiffs. So in many respects it operated like a class action, but it wasn't a class action because it wasn't purporting to have any effect on anybody outside the named plaintiffs in that case. And certainly had there been determinations, no one other than the plaintiffs would have been, no one other than the parties would have been bound. And also Heritage, which is the second case I've mentioned there, another bushfire case from Western Australia. which ended up going all the way to the High Court, and that's the reference there for the High Court case. But again, another one where there were a number of named plaintiffs involved. So,
why was it done that way?
I think I can say in relation to Creary that it was done that way because the proceedings were brought by 4 insurers, and so the insurer, I assume, I don't know, I don't think I ever asked anybody, but my impression is they are bringing claims on behalf of policyholders who are their policyholders, and they're not necessarily looking to take on responsibilities in relation to people who aren't their customers. I think that's what the driver was there. So, just in conclusion, so really what I'm trying to flag there is that what we've got there is it's a procedural framework that's actually of itself quite neutral, quite flexible, can accommodate some very different kinds of claims, which is really what I've tried to illustrate today. Usually the driver is money, because class actions cost money to run, and if you've got potentially thousands, hundreds if not thousands of affected persons, you may have a very large claim. But what's interesting is that some of these human rights claims in recent times have been seeking other outcomes as well, and as part of the court can't order an apology from the Parliament, but as we saw in Street, you can negotiate one. So that's an interesting development in that space. One of the things that we're seeing also is that seems to be quite not just a greater diversity in types of claims, but also there seem to be quite a lot of new firms moving into class actions. And I was reviewing, King & Wood Mallison every year does a review of class actions. The 2023-24 review that was done in the middle of last year found that there were some 44 class actions filed. Of those 44 were filed by 25 firms. And of the 25 firms who filed class actions, almost half of them had not previously filed a class action. So that's almost half of the new players in that year.
Were they in new areas?
I didn't break it down to that level, but what's interesting is that it, certainly from the point of view of counsel, where it's interesting for us is that quite often we're brought in to supply familiarity, background expertise in that space for firms who are looking to come into that space. So anyway, I'll pass on to Katie.
So within the next 12 months, Australia's highest courts will answer several fundamental questions of class action law and practice. In this discussion, I will first briefly outline some of the key cases and developments to watch. These include cases on appeal with decisions of importance in respect of group cost orders, common fund orders, group closure orders, and the assessment of damages and causation in shareholder class actions. So these topics obviously contain large areas of complexity within themselves, and I don't intend to address them in any detail apart from providing a general overview of the areas where change or clarification is on the horizon in the class action landscape. I will then turn to discuss some of the potential growth areas for class actions in Australia. And what I mean by growth areas is areas where we have seen some class action proceedings already, and when there is scope for growth and development of these types of claims. The two areas that I will provide an overview of in this regard are firstly privacy and cybersecurity, and secondly environmental, social and governance claims, often referred to as ESG claims. So first of all, some cases to watch in 2025. One important development to watch is the potential operation of Australian cross-vesting legislation in cases where group costs orders applies. So by way of recap, what is a group costs order? In effect, a GCO allows contingency-style fees in group proceedings, but in Victoria only. There is no counterpart in the federal court or any other Supreme Court of a state or territory. Thus, a GCO provides a funding mechanism for group proceedings that is unique to Victoria, and it has been a magnet for group claims to be filed in the Victorian Supreme Court. However, one potential limitation on the ability of a GCO to operate only in Victoria arises from cross-vesting legislation. Cross-vesting legislation generally requires proceedings within Australia to be determined in the more appropriate forum. In the Arium class action proceeding, and the citation for that is 2023 VSCA 256, the Victorian Court of Appeal declined to transfer the proceedings to the New South Wales Supreme Court, even though New South Wales had stronger connecting factors than Victoria. The court held that the fact that a GCO had been made was a relevant factor in exercising the discretion whether to transfer or cross-vest the proceeding to New South Wales. The court also held that even if it was to be transferred, the GCO would not travel or remain in force in the court of another Australian jurisdiction. The proceeding has been removed to the High Court for determination. The High Court will determine first whether GCO is in fact relevant to a transfer, and second, whether the GCO travels to the other court when it is transferred there, even though the court would not otherwise have had the power to make a GCO. The High Court's decision will likely have significant implications for the ability of a plaintiff to choose to file a class action in Victoria to take advantage of the GCO regime. A second development to watch is developments in common fund orders. So there have been some recent important decisions by the full Federal Court of Australia that seek to clarify and extend the operation of CFOs. By way of recap of some of the uncertainty that has existed with respect to CFOs over the last few years, in 2019, the High Court in Brewster ruled that the federal class action regime and its New South Wales equivalent did not empower courts to make commencement CFOs. This led to uncertainty as to whether CFOs could still be made at the settlement of class actions, and a split in authority at first instance emerged. In the Elliott-Cardet case, which is a case that Hernan has already mentioned, and the citation for that is 2023 FCAFC 162, the full federal court held that the federal court has the power to make settlement CFOs if the court is satisfied that it is just to do so. Later, in the Blue Sky case, and the citation for that is 2024 FCAFC 89, the full federal court went even further and held that the power to make CFOs extends to making a solicitor's CFO, providing for a percentage of the settlement or judgment sum to be distributed to solicitors acting for the class action. The defendants to those proceedings have filed separate special leave applications to the High Court of Australia, and special leave has been granted. The questions for appeal in substance are, first, does the federal court have power to make a CFO at the time of settlement or judgment in a class action? And second, if the answer to the question is yes, does the federal court have power to order a solicitor's CFO? If the High Court upholds the Blue Sky decision, the federal court may see a greater share of class action filings than in recent years, as it would permit an applicant's solicitors to a percentage of any recovery. Another general area to watch in 2025 is cases concerning loss and damage in shareholder class actions. Obviously, this is a very large and complicated topic in itself that I don't propose to go through in any kind of detail, apart from to flag the uncertainty and the fact that appeals have been lodged in important cases which are expected to clarify principles. So briefly, recent judgments in shareholder class actions in 2023 and 2024 have failed to secure an award of damages in class actions against large listed corporates. Those judgments have raised questions about how causation, loss, and damage can be established and quantified in those types of cases. And secondly, the type of expert evidence necessary to establish and quantify loss and damage. Appeals have been filed in 2 of those cases, Crawley and Worley. The citation is 2023 FCA 1613, and Zonia Holdings and the Commonwealth Bank of Australia 2024 FCA 477, which is another case that Hernan mentioned earlier. Both those cases allege that for different reasons, the respondent companies made misleading and deceptive statements and or breached their continuous disclosure obligations, which Hernan already alluded to is one of the common features of these shareholder class actions. The Worley appeal is listed for hearing before the full federal court in March, and the CBA appeal was heard before the full federal court in November, with judgment currently reserved. So the appeals are expected to clarify issues relating to establishing liability, causation, and quantification of loss and damage. Another area to watch is that of class closure orders. By way of recap, in a class action proceeding, parties may seek a class closure order, usually before mediation. As you may know, a class closure order is an order that requires potential group members to take a positive step by registering their interest to participate in the class before a certain date. There are conflicting views between the Federal Court and the New South Wales Supreme Court as to whether a court has the power to make such orders ahead of a mediation. In the Palace case, Palace and Lendlease Corporation, 2024 New South Wales Court of Appeal 83, the Court of Appeal was referred a special question as to whether notice could be given to group members of a right to register to participate in any settlement achieved through a mediation, coupled with notice of an intention that the parties would seek an order binding unregistered group members to the terms of any resulting settlement and prohibiting them from seeking any benefit from the settlement. The Court of Appeal confirmed that such a notice is beyond power. In the interest of time, I won't go into the topic in any more detail, apart from noting that in November 2024, an appeal of the Court of Appeal's decision in Palace was heard by the High Court and can be expected to resolve the question of whether the power exists to make such closure orders. The next general topic I wanted to turn to is the potential growth areas for class actions in Australia. The range of areas for class actions continues to expand and evolve, and I'll briefly touch upon 2 of those evolving areas. Firstly, cybersecurity and privacy, and secondly, environmental, social and governance claims, or ESG claims. So firstly, cybersecurity and privacy. Relatively recently, a series of cyber incidents led to the rise in privacy and data breach related class actions in Australia. By way of example, there are a series of cases against Medibank following an alleged data breach in October 2022, where it is alleged that hackers extracted the personal and health claims data of Medibank customers, and some of the stolen data was publicly released via the dark web. The Medibank class actions comprise, first, a consolidated consumer class action that is running in the federal court based on misleading or deceptive representations about the company's cybersecurity controls. Secondly, a consolidated shareholder claim against Medibank running in the Supreme Court of Victoria. In this case, it is alleged that Medibank engaged in misleading or deceptive conduct and breached its continuous disclosure obligations by not disclosing information regarding alleged deficiencies in its cybersecurity systems, and that this caused the price of Medibank's shares to be greater than their true value. The plaintiffs and group members seek compensation for purchasing shares in Medibank at an allegedly inflated price due to the alleged conduct. There is also a class action in the federal court against the Optus Group in relation to an alleged data breach that occurred in September 2022. In this class action, a recent question that has come up is whether the forensic reports procured by Optus and that were prepared by Deloitte in respect of the breach were subject to legal privilege. The primary judge concluded that the Optus parties had multiple purposes in procuring the review and report prepared by Deloitte, and rejected Optus's privilege claim on the basis that Optus had failed to discharge its onus to show that the legal purpose for procuring the Deloitte report was dominant. and leave to appeal that decision was refused. And the citation is 2024 FCA FC 58. The decision is a timely reminder of the well-established principles that should be borne in mind by lawyers when procuring such a forensic report following a suspected data breach. While the specific causes of action in these different class actions differ, there are some common themes. The first theme is that the defendant is subject to certain regulatory requirements regarding data handling and cybersecurity that were allegedly breached, including, for example, the Australian privacy principles under the Privacy Act, or industry-specific regulations such as for Medibank, the Health Records Act, and for Optus, the Telecommunications Interception and Access Act. The second theme is that the defendant's failure to comply with applicable regulatory requirements amounted to a breach of contract for failure to comply with data handling and cybersecurity statements contained in customer contracts, policies and terms and conditions, and that's a feature of the consumer claims. Sure.
Loss that's being claimed in the consumer action. So I'm a customer, my data's breached. What sort of losses are being claimed by members of the class?
Yeah, and I think that's one of the key hurdles to these kind of class actions that you see is establishing economic loss and damage as opposed to prospective potential loss or damage. And there has been a recent case, I don't have the citation, that was dismissed by the court at first instance because essentially the plaintiff, it wasn't a class action, but the plaintiff didn't show actual loss, only the potential for loss. So I do think that's that precise issue is the issue to watch, how an economic actual loss can be established. You can bring a representative proceeding under the Privacy Act and claim non-economic damage. So I'll touch on a case as an example of that. So that is one avenue that you can go to for claiming non-economic loss, and damages have been awarded in that forum for things like psychological distress and emotional harm and the time taken because of the breach, things like that. Yeah. And following on from that, there's also a new statutory tort of privacy that has been introduced. A statutory tort of invasion of privacy that has been introduced through amendments to the Privacy Act. So by way of background, in September 2024, the Privacy and Other Legislation Amendment Bill was introduced, and in December 2024, the bill received royal assent. Among its provisions, the bill establishes for the first time a new statutory tort of privacy, allowing individuals to sue for serious invasions of privacy. So the relevant provision reads that an individual, the plaintiff, has a cause of action in tort against another person if the defendant invaded the plaintiff's privacy by doing one of or both of the following: intruding upon the plaintiff's seclusion or misusing information that relates to the plaintiff, and a person in the position of the plaintiff would have had a reasonable expectation of privacy in all the circumstances, and the invasion of privacy was intentional or reckless, and the invasion of privacy was serious, and the public interest in the plaintiff's privacy outweighed any countervailing public interest. And to your point, it says that the invasion of privacy is actionable without proof of damage, and also provides for the award of non-economic loss or damage for that new tort that's just been introduced. There are various defences to the new cause of action, such as consent, and exemptions apply for law enforcement agencies and journalists, for example. So the potential impact of this new tort in cybersecurity-related class actions is untested, but its potential is there. As I briefly mentioned before, it should also be noted that a form of representative proceedings is also possible under the Privacy Act itself. So individuals may have recourse for breaches of the Privacy Act by lodging a complaint with Australia's federal privacy law regulator, the Office of the Australian Information Commissioner, via the representative complaints regime under that Act. And the Commissioner will then investigate the complaint except in certain circumstances. One example is the Commissioner's determination requiring payment compensation for non-economic loss to individuals affected by the Department of Immigration's disclosure of personal information of over 9,000 individuals in immigration detention at the time. And that provides an example in that schedule of the types of non-economic loss that can be claimed and the grading of the, psychological harm and the monetary amount that assigns to that degree of psychological harm. And the reference to that particular determination is WP and Secretary to the Department of Home Affairs Privacy, 2021 AI CMR 2, 11 January 2021. So the final area I will touch on today is the potential growth of ESG class actions. ESG issues continue to dominate the corporate governance agenda in Australia and globally. There is an emerging global trend of using public international law principles or instruments to attack large corporates in relation to climate change issues, especially where those corporates have stated their adherence to those norms. In addition, companies that fail to adequately disclose material climate change risks or make climate-related commitments without a reasonable basis will be vulnerable to shareholder class actions for misleading and deceptive conduct. Many disclosures relating to climate change could constitute representations as to future matters. And as you know, under the ACL, that shifts the onus of proof, and those disclosures will be regarded as misleading unless made with a reasonable basis. It can sometimes be useful to look to what's happening on the international stage to see where some of the trends in the environmental litigation might happen in Australia. So looking at a few examples of international cases, one such case is a claim in the Netherlands that was brought by Friends of the Earth and other co-plaintiffs, including 17,000 citizens, against Shell, alleging Shell's contributions to climate change violate its duty of care under Dutch law and human rights law. The plaintiffs sought a ruling from the court that Shell must reduce its CO2 emissions by 45% by 2030 compared to 2010 levels, and to zero by 2050, in line with the Paris Climate Agreement. This case built on another Dutch landmark decision, which found that the Dutch government's inadequate action on climate change violated a duty of care to its citizens. In this particular suit against Shell, the plaintiffs extended this argument to private companies, arguing that given the Paris Agreement's goals and the scientific evidence regarding the dangers of climate change, Shell has a duty of care to reduce its greenhouse gas emissions. The plaintiffs base this duty of care argument on the Dutch Civil Code and also when read in light of certain European Convention on Human Rights obligations. There was an initial decision in May 2021 by the Hague District Court in favour of the plaintiffs, and the court there ordered Shell to reduce its emissions by 45% across all activities, including both its own emissions and its end-use emissions. Shell appealed the decision, and recently in November 2024, the Court of Appeal in The Hague issued its judgment on the appeal. It followed the first instance court by deciding that Shell carries a legal duty of care to curb climate change. That was following from Dutch tort law, read in light of international human rights law instruments, as well as EU and international climate law. However, the appeals court overturned the judgment by refusing to impose specific emission reduction targets for Shell, concluding that there was insufficient scientific consensus about a special reduction percentage that should be applied to an individual company. Another international example is one that comes from the UK, where one of the largest class actions in the world has been filed, and that case concerns a dam collapse disaster in Brazil The dam was operated by a joint venture between BHP and Vale, which caused widespread environmental damage and displaced communities. And the class action involved hundreds of thousands of claimants from Brazil seeking compensation for the damages caused by the dam collapse. BHP challenged the English court's decision, among other things, on the basis that the incident occurred in Brazil and the claimants were all based in Brazil. The Court of Appeal, however, ultimately ruled that the English courts do have jurisdiction, citing the inadequate compensation available to victims in Brazil and the fact that the BHP is a UK-based company. So that's just an example of how even if an environmental event occurs overseas with foreign-based plaintiffs, there still is potential for an action to be brought in Australia, for instance, if the defendant is based in Australia. So now turning to Australia and some of the examples of recent ESG class actions. One that's already concluded that you may be aware of is the Montara oil spill class action in favour of the Indonesian seaweed farmers. So those parties subsequently agreed to settle the proceeding for over $192 million. And I won't go into more detail of that because I note that we're running short of time. But one class action that is currently on foot and which is set to be heard is the Pabai class action. This class action was commenced in the federal court in 2021 by the applicants on behalf of all peoples of the Torres Strait. The applicants are seeking damages from the Commonwealth on the basis that the Commonwealth owed a duty of care to take reasonable steps to protect Torres Strait Islanders, their environment, and their traditional way of life from climate-related harm, whether current or anticipated. In the proceedings, the applicants seek damages, including for degradation of the land and the marine environment, including life and coral systems, and also physical and psychological injury. The applicants also seek an injunction in that case, requiring the Australian Commonwealth to implement measures that are necessary to protect the land and marine environment of the Torres Strait Islanders from greenhouse gas emissions. Secondly, to reduce Australia's greenhouse gas emissions. And thirdly, to otherwise avoid injury and harm to the Torres Strait Islanders. Pabai was heard late last year and the federal court is yet to deliver judgment. This is an important case, and a finding that such a climate-related duty of care exists would represent a shift in how parties in Australia consider climate-related actions and may offer, and would likely offer, further scope for climate-related class actions. Related to that particular class action is not a class action as such, but it's the petition of the Torres Strait Islanders to the United Nations Human Rights Committee alleging violations stemming from Australia's inaction on climate change. And based on that petition in September 2022, the UN Human Rights Committee found that Australia's failure to adequately protect Indigenous Torres Strait Islanders against adverse impacts of climate change violated their rights to enjoy their culture and to be free from arbitrary interferences with their private life, family and home. So that's not a class action as such, but it's worth mentioning as it does reveal how plaintiffs can utilise multiple strategies in forums in climate-related cases. So lastly, this is my last topic, greenwashing cases is another example where one may expect to see class action growth in Australia. A 2024 report by the Grantham Research Institute on climate change and the environment states that the number of cases concerning climate washing or greenwashing has grown in recent years. On a global scale, 47 such cases were filed in 2023, bringing the recorded total to more than 140. The report states that these cases have met with significant success, with more than 70% of completed cases decided in favour of the claimants. In addition, greenwashing is a key enforcement focus for ASIC, and you may have seen that in 2024, ASIC brought 3 actions against corporates alleging greenwashing. 2 actions being those against Mercer, Superannuation and Vanguard Investments, related to misleading statements in respect of the company's investment products, and resulted in significant penalties, all for both of them over $10 million respectively. So regulatory actions against Australian companies for alleged greenwashing practices may lead to increased shareholder class actions. For example, if a listed company's share price declines significantly once the alleged misconduct is disclosed to the market, or if it can be established that the share price was artificially inflated beyond its true value as a result of the misconduct. However, the current uncertainty in quantifying loss and damage arising from alleged misleading environmental statements may be one of the main hurdles to commencing these types of class actions. So that's the end of my discussion. Thank you.
Question.
Sure.
Yes, so my question is about the ESG class action. So obviously it's more for public purposes. So how is that interact with, for example, group cost orders, common fund orders, and things like that? Like, would that be taken into account as a part of the claim in terms of the cost of compensation? Because I know that for the commercial class action, they highly focus on like these kind of cost orders, but how is it different in the ESG class actions?
I think it's fair to say that the availability of group cost orders and common fund orders address what is a fundamental problem, which is free riders. If you're bringing a class action proceeding, quite often there are some fairly high costs involved, and you'll need to get, for example, a funder involved. The funder will want their money back, basically through those proceedings, and so I think it's fair to say that the same mechanisms will be relevant for, depending on the environmental class action. You'll still have the same problem, which is ultimately somebody has to bring the proceeding, somebody has to outlay the cost, the expense of running it. Obviously what happens in terms of decisions about powers of courts to make those sorts of orders that bind all the members of the group to contribute to the costs of the proceedings will be fairly important as to whether or not you can actually bring those sorts of actions. And we've seen in Australia certainly a bit of movement, as Katie was flagging before, to jurisdictions where, for whatever reason, people feel that there's a better, a greater ability to give funders the certainty that they will get the orders at the end of the proceedings that they would want to be able to have that certainty.
Might I ask a question?
Yes.
Thank you. Thank you for your wonderful presentation, both. I just want to touch on the cybersecurity data breach question, the class actions. I recall, and I'm not sure, there was some sort of carriage issue, or pseudo carriage issue, between the data breach class actions and the OAC representative proceeding abroad. And I can't recall whether that was resolved or cured, because I recall that being a major hurdle because it wasn't clear which form it should be for. Has that been resolved? Where is it supposed to go? Is it the Fed?
It's been a while since I read those decisions, so I'd have to check. And yeah, and I'm happy to email and follow up with you after this discussion. But it's not on my immediate recall is not reminding me of what happened in that space.
Sorry, did you?
You've mentioned some limitations as to the type of orders that can be made, and for a class action, such as in human rights, they potentially couldn't order an apology. And you've mentioned the tension between proving entitlement to particular orders, such as presumably in the PMI one, and I haven't read it or been involved in it, but I was hoping you could provide some insight. Is it in dispute, the legal question of whether or not certain orders about the reduction in emissions and so forth can be made in Australia, or is it primarily a question of evidence at the moment as to whether or not it can be proved that that will be useful, or that there was causation or so on?
From memory, I don't think there's a requirement that it's an issue in that case that there be a particular specific reduction, although that was in the Shell case.
An injunction for measures to protect land or marine environment, for instance, I suppose.
Yeah, I'd need to go back to the case to look exactly what was sought as part of that injunction.
Thank you.
All right, if there's no further questions, I think we should adjourn and have a more sort of informal discussion. Have